I made a couple of procedural errors in my last two filings. In the case against Sarasota Memorial Hospital, um, the appellate court affirmed the lower court's ruling, and uh, and then I filed to invoke the jurisdiction of the Supreme Court. And the appellate court sent that right away to the Supreme Court, and the Supreme Court right away rejected it. The appellate court knew what I didn't, that I had to have a written opinion from the appellate court. You can't just use the same one that came from the lower court that was just affirmed by the appellate court. So then I filed a motion in the appellate court for a written opinion. And the defendant or appellee filed opposition to my motion, and then that gave me the opportunity to reply to that response to my motion. So I filed. I'll try and remember to post it in the YouTube description below this video. So I replied to that. The precedent is the Dred Scott versus Sanford case of 1857. And so when the judge kind of, it's weird, man, says, well, this other judge said that it's a matter of law that he can say this is not, does or does not measure up to the standard of outrage necessary for the tort. And I'm like, no, where's the law? Where's the law that says you get to decide by decree? So it was sort of preposterous. And right from the beginning, the idea that a baby boy doesn't have the right to possess his body in its entirety, the one he's born with, foreskin is not a birth defect. Well, that's preposterous also. So after the U.S. Civil War, it was, partly resultant of this really, really bad ruling of the Supreme Court, Judge Roger B. Taney and company. The U.S. ratified the 13th and 14th Amendments. No slavery, and newborn baby boys are being treated as de facto slaves. That's the 13th Amendment. 14th Amendment, equal protection. And they're not getting it. You can't treat anybody else in the country that way. Non-consensual elective surgery. What in the hell are they thinking of? So anyway, I replied, did I say that? Yeah, reaffirming my desire to have the written opinion of the appellate court. Then in the other one, against the state attorney here, there's 20 state attorneys in Florida, a bunch of assistant state attorneys, and there's one attorney general. Well, I sued the state attorney in my district or circuit, whatever they call it. And so I thought that 20 days had passed that they have to respond. And I was wrong. I saw the date on the summons form where the clerk had approved it, and I took that as the day that it was filed. But no, it came back 2 days later and was after having been served. So they had until today, instead of Monday. I guess today's Wednesday. I don't know. So then right away, because I didn't know who was representing the state attorney, they have outside counsel, and he filed. When he saw what I had filed, he filed a motion for an extension of time, which it's very common for the judge to grant those. People just get backed up. But he was really tardy in asking for it. He waited until the very end and my prompt. So hopefully, since that's the case, the judge at least won't give him the 20 days he wants, and maybe said, no, get it in by Friday or something like that. But it's so frustrating. I was watching Sotomayor, the Supreme Court Justice, on TV yesterday, or YouTube One, and she just talked about how frustrating and traumatizing it is when something that you feel so strongly about goes against you, and it's that feeling. And when I got that affirmation from the appellate court, on the Sarasota Memorial Hospital case. Son of a bitch. I have really to be careful that I don't start cussing the judges, which happens. Um, the point is that, but then I realized after a little bit of time passes, another day, that I just went further up the learning curve, and so it was all toward a good end. And so the writing that I have to do, the legal memorandum writing, it's quite tedious, but it gets better. You have to cite the facts and cite the law, and then cite precedent. And the precedent stuff is just sometimes people will just vomit precedent into their motions or into their pleadings, and just really confuse the issue. And I don't do that. I just cite the law, and in this case, the facts. And in fact, when I took the opportunity to reply, um, doubling down on my request for a written opinion from the appellate court, I put in the video link to the procedure, because people are like out of sight, out of mind. They're not bothered by it because they're not looking at it. And so I took the opportunity to, here it is, look at it, please look at it. And then, so there's the fact, and then the rule, the law, is, gosh, equal protection and my inviolate right to a trial by jury. And the precedent, this has been suggested a long time ago to me, that this voice rights against this circumcision thing was today's version of the abolitionist fight. And then, I think it was really this past week or two that really I came to see it as wholly applicable and exacting in its precedent to the current case. You cannot treat baby boys as slaves, and you must give them equal protection. All right, thank you.